to thank you for those kind words. You have no idea how happy I am as a legal academic to get applause before I begin to speak. Before I begin, I want to acknowledge the work of 3 students in this room who've worked on this project. The first is Maddie Hill, who is the co-author of an article which the McGill Journal of Law and Health has promised to publish sometime before I die. The second is Harleen McClure, who's worked with me and done a considerable amount of research and has prepared a number of important memos that we have sent off to the director of the Canadian Institute for Studies on Substance Use in BC, who's been asked to be an expert witness in what will be the first alcohol-related civil suit brought against the industry for failing to warn. And finally, I would like to thank Elise Kim, who has worked and edited and helped me in terms of a number of the projects. All right, let's begin. In November 2017, the Yukon Liquor Authority began to attach enhanced warning labels to the alcohol products it was selling out of its Whitehorse store as part of a Health Canada national study. The purpose of the study was to determine what impact, if any, alcohol warning labels would have on alcohol consumption and knowledge of risk. Now, the Yukon government had every reason to be concerned about alcohol. The Yukon had the highest per capita alcohol consumption, rate of alcohol consumption in the country, 58% higher than the national average. Its alcohol-related hospital admission rate was 3.5 times the national average. And for every dollar alcohol generated in government revenue, it generated $2.25 in social costs. The alcohol industry's response was immediate and aggressive. It publicly condemned the study. It complained to the Vice President of Research at the University of Victoria that the principal investigator was unethical and biased, that the study was rigged, and they threatened to sue the Yukon government. And it was at that point I was asked by the lead researcher of the project to look at their legal arguments. Their arguments were completely without merit. If any of you in the room had made these arguments, you would not have done well in my class. But it didn't matter, because the industry's response was typical of how the alcohol industry has used the threat of law to undermine, delay efforts to enact alcohol warning and health information legislation. The Yukon government buckled within 4 weeks. The study was paused on December 19th, 2017. One of the 2 enhanced labels was a cancer warning that was withdrawn. And the Yukon Liquor Authority sought common ground with the industry. Now, the government publicly indicated that the study had merit, but stated that they could not afford to take on the industry. That is not good. Okay. And they called upon the federal government to introduce national alcohol warning and health labeling legislation, to which, as we shall see, lots of luck. Okay. Ironically, the Liquor Authority was not vulnerable to civil suit for attaching enhanced labels, but rather was vulnerable for not doing so. Moreover, the industry was vulnerable not for failing to warn of the risk of cancer, but failing to warn of the risks of fetal alcohol syndrome disorder. Now, fetal alcohol syndrome disorder, like other prenatal injury cases, involves two separate claims. For those of you who may not understand, a prenatal alcohol claim, typical example, a woman is in a car crash, the negligent driver injures the pregnant woman, the fetus is injured, it is born alive. And in that circumstance, two civil suits can be, or two claims can be made. One on behalf of the injured child for the injuries it suffered during the pregnancy, and a second claim by the child's parents for any additional costs they've incurred and any additional services they have provided. So in this presentation, I'm going to turn all of the students in this room into mean, lean legal machines. My faculty colleagues, you are on your own. On the nature, probability, and severity of FASD, the federal, provincial, and territorial government's failure to enact meaningful alcohol health warning legislation, and the potential civil liability of alcohol manufacturers and government liquor authorities for failing to warn of the risks. I'm not a big fan of using civil liability as a means of advancing public health policy. It's slow and it is costly. But when all else fails, sue. Me and technology don't get along. Okay. So, first thing, fetal alcohol syndrome disorder. Fetal alcohol syndrome disorder is more common than all other kinds of developmental disabilities combined. It is twice as common as autism, 17 times more common than cerebral palsy, 20 times more common than Down syndrome, and 40 times more common than Tourette's. FASD's prevalence has most recently been estimated at 4% of live births in the general population, and 8% among special populations, which the author said was composed of children in care, those involved in the criminal justice system, and members of the indigenous community. Now, FASD is a broad diagnostic term that encompasses three related diagnoses, typically listed in descending order of severity. First, fetal alcohol syndrome. Second, partial fetal alcohol syndrome, which is referred to as PFAS. And finally, alcohol-related neurodevelopmental disorder, or ARNT. Most researchers divide ARNT into ARNT-B, which is problems related to behavior, and ARNT-C, problems related to cognitive disabilities. Other researchers also include alcohol-related birth defects, which involve injury and risk in terms of heart, bone, hearing, and premature death. Now, all three of the traditional diagnoses result in lifelong cognitive and behavioral harms, but only FAS and partial FAS involve facial dysmorphology, that is the characteristic facial issues, thin upper lip, small eye, flat features, etc., and growth deficiencies. PFAS and ARNT are far more common than FAS. ARNT, and to a lesser extent, PFAS often go undiagnosed. Okay. Unlike breast and other cancers, FASD is caused exclusively by prenatal consumption of alcohol. One of the problems about suing the alcohol industry for failing to warn of the risk of cancer is that the great majority of cancers aren't caused by alcohol. And so there will be difficulty establishing causation. But not with fetal alcohol syndrome, because all cases of fetal alcohol syndrome are caused by alcohol. FASD harms range from mild cognitive behavioral deficits to profound disabilities, etc. Now, an infant's likelihood of suffering or being born with FASD depends on a number of variables. The total amount of alcohol a woman consumes during pregnancy, the time when in the pregnancy the alcohol is consumed, the mother's genetic makeup, age, and other variables. In terms of the mother's genetic makeup, there is a maternal alcohol metabolic gene variant, which means that women who drink the same amount of alcohol in the same circumstances, some may be far more prone to FAS, some may be far less prone. In other words, there is an element of uncertainty due to the genetic makeup of the mother. The final factor is the frequency of binge drinking, commonly defined as consuming 4 standard drinks in one sitting for women. The research also indicates that facial dysmorphology and the most profound cognitive disabilities result from consumption of alcohol in the 3 to 8 weeks post-conception, a time when many women may not be aware that they are pregnant. Notwithstanding the high prevalence of FASD, the great majority of infants who are exposed to prenatal alcohol consumption do not develop FASD. So you're now whizzes on fetal alcohol syndrome disorder. We're now going to turn and look at what the government has done in response to the risks posed by fetal alcohol syndrome. Well, there are prominent federally mandated cancer warnings, pregnancy warnings, addiction, and other warnings on all tobacco and cannabis packaging. The following tobacco and cannabis labels are among the least alarming federally required graphics and texts. That's the smoking. Many of the smoking labels, which now cover 75% of the package, are really disgusting and alarming. This is the tobacco THC cannabis warning that relates to birth defects. Do not use if pregnant or breastfeeding. Using cannabis during pregnancy may harm your baby and result in low birth weight. Now, despite the fact that alcohol was first classified or categorized as a Class 1 carcinogen in 1988 by the World Health Organization, a Class 1 carcinogen is a substance that is known to cause cancer in human subjects. Alcohol is not subject to the kind of stringent advertising, marketing, and labeling restrictions that apply to tobacco and cannabis. Now, the federal government's hands-off policy stands in sharp contrast to the harms caused by alcohol. As of 2020, it was estimated that alcohol was responsible for 17,000 deaths and $19.7 billion in social costs. That figure is $6.4 billion higher than all government net revenues. Now, 9 private members' bills were introduced into Parliament between 1986 and the year 1988 and the year 2006. The first 8 died on the order papers. The 9th was defeated. The most recent private members' bill mandating alcohol warnings was introduced by Senator Brazeau, who is probably most well known for his boxing match with Justin Trudeau, which, by the way, he lost. My guess is more people would be cheering for Brazeau now than before. Okay. The most recent federal private members bill died on the order papers in January 2025. Senator Brazeau has indicated that he intends to reintroduce this private members bill, but it is unlikely to be any more successful. A study of private members bill indicated that less than 1%, less than 2% are ever enacted into law, and of those, only half deal with substantive law. The other half of private members' bills are things like declaring day X to be bicycle day or something. So the likelihood of Senator Brazeau's bill passing is limited. Now, this is the health information currently on Canadian alcohol products. That is the total volume and the percentage of alcohol by volume. The circle is mine. I want to take a lot of credit for that because I did that all by myself without the help of a research assistant. So the circle doesn't appear. Now, I should say as well, there's other important health messaging on Canadian alcohol products. Irish whiskey has to come from Ireland. Okay? Canadian whiskey has to come from Canada. Okay? But that's basically it in terms of health warnings. Okay, I'll go back. Now, the provinces have initiated a number undertaken a number of measures, but no province or territory has enacted mandatory alcohol warning and health labeling legislation. So the feds have done zip, in contrast to what they've done in terms of cannabis and tobacco. The provinces have a number of initiatives, but they have not introduced legislation. All right. So now that you know a lot about FASD and know that the feds and the provinces have not introduced legislation, the next issue is, how do we get progress? How do we move the issue forward as a public health issue to ensure that women are informed of the risks? Okay? And so this section, we're going to look at the potential civil liability of alcohol manufacturers and suppliers for failing to inform consumers of the risk of FASD. This is the boring bit for me, because this is just old hat tort law. This is not the application of new and innovative legal concepts to what we know about alcohol. This is applying principles which have existed for decades to what we know about alcohol and FASD. Okay, so common law principles of negligence would govern FASD claims throughout Canada, with the exception of Quebec. In Quebec, the FASD claim would fall within the civil code. Suffice it to say, the likelihood of a successful suit in Quebec is far broader than in the common law jurisdictions. The principles, common law principles of negligence are not as broad as the Quebec principles of liability under the Civil Code. Now, before turning to the analysis of an FASD claim, I have set out in the PowerPoint the elements of a negligence action. The plaintiff has the burden of proving the first 5 elements on a balance of probability, and the defendant has the burden of proving defenses to the same standard. Okay, I'll go over these relatively quickly. The plaintiff must establish as a matter of legal policy that the defendant owes them a legal obligation to exercise care. The plaintiff must establish on the balance of probability that the defendant has breached the requisite standard of care. The plaintiff must establish on a balance of probability that the defendant's breach of the standard of care was a cause of the claimed losses. The plaintiff must establish that the claimed losses are not too remote in law. Sorry, I'm a little bit hoarse, sorry. Not too remote in law to be recoverable, and the plaintiff must establish damages and their extent, and the 6th element is the defenses. The defendant may allege various defenses which would reduce or negate the claim. Okay, turning first to the duty of care. And we're simply going to apply these principles to what we know about FASD. Okay. Supreme Court of Canada has repeatedly held that all manufacturers and suppliers have a broad common law duty of care to inform consumers of the risks inherent in using their products. As noted by Laforet and Hollis and Dow Corning, it cannot be said that requiring manufacturers to be forthright about the risks inherent in the use of their product imposes an onerous burden on them. Now, at one point, an injury to a fetus, even if born alive, did not give rise to a claim. Now, that was changed. And so the fact that an infant born alive was injured as a fetus is no longer a bar to recovery, with one important exception. So the fact the fetus was injured as a result of the mother's consumption of alcohol is not a bar to an action by the manufacturer. Now there's one exception to that, and that was established in the case of Dobson, in which the Supreme Court of Canada held that a mother does not owe a duty of care in negligence to their fetus. I have difficulty with the decision on other grounds, but it's important for current purposes because it means that if the alcohol manufacturer is sued by the infant and held civilly liable under the common law, the manufacturer cannot join the mother as a co-defendant and cannot raise the mother's drinking, whether it was irresponsible or not, as a defense. And so Dobson, in many ways, makes it far easier and provides some benefits to suing that would not otherwise exist. Okay. Now, the vast majority of duty to inform cases involve manufacturers. But the courts have also made it clear that these same principles apply to suppliers of products. In Canada, provincial and territorial liquor authorities have monopolies on the wholesale alcohol market. Now, in Alberta and some other provinces, the retail alcohol market is in private sector hands. But in all jurisdictions, can you see now, Kyle? Okay, in all jurisdictions, the provincial liquor authority is the exclusive wholesale supplier of alcohol. So what that means is that, like alcohol manufacturers, the provincial government, as suppliers of alcohol, have the same liability. Now, manufacturers and suppliers have no duty to warn of risks which are obvious or well known. And you can bet your bottom dollar the industry will argue long and hard that the risks of FASD are well known and obvious. However, situations in which a risk is obvious or well known has to be distinguished from situations in which the consumer has only a vague understanding of the risk, is unaware of the severity of the risk, is unaware of the prevalence of the risk, or is aware of only some of the risks. Now, most women in Canada have heard of the term FASD and understand they should limit drinking during pregnancy. However, many women may be unaware of the fact that their fetus can suffer profound disabilities due to alcohol-related harm before they realize they're pregnant. As one UK commentator noted, current public health advice to abstain from alcohol throughout pregnancy overlooks two important reproductive realities for women. Almost half the pregnancies in the UK are unplanned, same percentage in Canada, about 47% are unplanned. And there is a period of time at the start of pregnancy, on average halfway through the first trimester, when a woman is unaware that she is pregnant. Similarly, many women may be unaware that FASD is the single greatest cause of developmental disabilities. So there is limited Canadian survey data on women's understanding of FASD, but it indicates that most women are unaware of the nature, prevalence, and severity of FASD. And therefore, it cannot be written off as a well-known or obvious risk. So my conclusion is that Canadian alcohol manufacturers and suppliers, which include the provincial liquor and territorial liquor authorities, have a common law duty of care to inform women of the risks that alcohol consumption poses of having an infant born with FASD. And remember that the most serious harm to the fetus generally occurs 3 to 8 weeks post-conception, a period of time in which, or at least for part of which, most women don't realize they're pregnant. Okay, the standard of care. Manufacturers and suppliers must inform consumers of the risks posed by both the foreseeable use and the foreseeable misuse of alcohol. The alcohol industry will argue that FASD results from an unforeseen pattern of alcohol abuse. That argument lacks merit given the high rates of binge drinking among Canadian women of childbearing age. Okay, so given the high rates of binge drinking among Canadian women, the risk posed by this pattern of use, including having a child born with severe FASD, cannot be written off as unforeseeable. In 2022, approximately 25% of women between the ages of 18 to 34 and 20% of women aged 35 to 49 were heavy drinkers. Defined as binge drinking at least once every month in the past year. Binge drinking is common among women of childbearing age. Alcohol manufacturers are required to tell the whole truth. They cannot bury, gloss over, or obscure the risk. If the risks are serious, a vague, general, or blanket warning will be insufficient. So, for example, in Buchan v. Orthopharmaceutical, the trial judge stated that it was inadequate to only inform women that complications could result from taking its birth control pills when the company knew that its product was associated with a dramatic increase in stroke. Actually, a 19-fold increase in stroke. So it's not enough to provide a general warning if the risks are serious. The Canadian courts have held manufacturers to a particularly high standard of disclosure in terms of products intended for human consumption. The information must be specific, detailed, and prominent enough to alert consumers to the nature, probability, and severity of any significant risk. Now, the alcohol industry will say, well, we are opposed to warning, we can't convey this information on the side of a bottle. And the response is, although framed as a duty to warn, it is a duty to inform. So providing a warning label is simply one of the means available to the industry to inform women. The information can be conveyed by attaching a warning or health label to the product or its packaging, developing a health-related public service announcement, including the information in all print and broadcast advertising. The standard of disclosure is generally higher in regard to products that are mass marketed to the public, particularly products that are marketed to those who may be vulnerable or young. Manufacturers can ignore a risk simply because they don't believe the research. The fact that information on FASD is available from other sources doesn't diminish the obligation of the manufacturer or a supplier to directly inform the public. Even if a warning is given, it has to be assessed in terms of the manufacturer supplier's overall marketing and advertising practices, including any countervailing messages that the industry has made that would undermine the warning. All right. Now, the alcohol industry will argue, we have complied with all federal and provincial labeling and packaging law. In the United States, if a manufacturer complies with a federally mandated message, that preempts civil liability. So there's this concept in the states of federal preemption. So the tobacco companies couldn't be sued, an alcohol industry couldn't be sued if it complied with a congressionally mandated warning. That is not the case. That is not the case in Canada. So the mere fact that a manufacturer's complied with federal or provincial labeling or packaging legislation provides no defense unless the federal or provincial law is, quote, coextensive with the common law principles, and clearly it is not. All right. So my conclusion, alcohol manufacturers and government suppliers have breached the standard of care by failing to directly and clearly inform women of, among other things, the prevalence of FASD, its potentially lifelong impact, the risks that the fetus may suffer profound harm before they realize they are pregnant. Next issue is causation. The plaintiff must prove on the balance of probability that the defendant's negligent failure to inform her was a cause of her loss. Establishing causation will likely be the most challenging of the most challenging and contentious element of an FASD claim. The causation issue involves three sub-issues. First, it must be established that alcohol caused the harm. This is sometimes referred to as the medical causation issue. This will be relatively straightforward with FAS because it is easily identifiable through the facial dysmorphology and limits on growth. And also not difficult in terms of partial fetal alcohol syndrome. Proving causation will be more challenging in terms of ARNT, which is harder to diagnose and distinguish from attention deficit hyperactivity disorder, ADHD, and other causes. So, second, the plaintiff must establish that had she been adequately warned, she would have not consumed the alcohol or would have limited consumption. This is sometimes referred to as decision or conduct causation issue. Now, the recent Canadian case law has made it easier to establish conduct causation. The Supreme Court of Canada has adopted what it is variously described as a, quote, robust, pragmatic, or common sense approach to proof of causation, which permits an inference of causation to be drawn in the plaintiff's favor in the absence of evidence to the contrary. The Canadian courts have tended to accept at face value a woman's testimony about the health decisions that she would have made. In Ortho, the Ontario Court of Appeal stated that the selection of a birth control method in the case of a healthy woman is not a matter of medical treatment, but of personal choice, and it is, quote, not unreasonable that notice of a serious potential hazard to users of oral contraceptives could influence the selection of another method of birth control. It is not unreasonable that it could influence. That was the standard in Ortho. In Letourneau, the Quebec multi-million-dollar tobacco suit, the judge stated that the seriousness of the tobacco company's fault, namely failing to clearly warn about the toxicity of tobacco, gave rise to a presumption that it was one of the causal factors that led to the plaintiff's smoking. The severity of the harm gives rise to a presumption, which in Letourneau the industry was unable to rebut. Okay. All right. Third, the plaintiff must establish that by abstaining or reducing their drinking during pregnancy, the harm would not have occurred. If a court accepts that a woman would not have consumed alcohol, then establishing this is straightforward because obviously if she hadn't consumed alcohol, the child would not have been born with FASD. Complex causation and evidentiary issues may arise if the court finds that the woman would have moderated her consumption rather than abstaining from it. Now, both alcohol manufacturers and the government liquor authorities can be sued. But in many cases, it's going to be easier to sue the government liquor authority. In a civil suit against the manufacturer, you have to prove that it was the alcohol manufacturer's product that caused the harm. No such problem arises in suing the provincial or territorial liquor authority because they have a monopoly. They are the supplier of all alcohol in the jurisdiction. So in many circumstances, it's going to be easier to sue the government in relationship to cause than to sue the manufacturer. My conclusion, children with FAS and partial FAS and their parents should have relatively little difficulty establishing causation, particularly in suing a government alcohol supplier. Proving causation will be more challenging in the case of children born with harm. The next issue is remoteness of damage. Remoteness of damage. The plaintiff must establish that their injuries are not too remote in law from the defendant's negligence to be recoverable. A woman will have little difficulty establishing that her child's FASD-related disabilities resulted from the failure to be adequately informed of the risk. Now, the general test of remoteness has been broadened by the adoption of the kind of injury test and the thin-skulled plaintiff rule, which apply. Once the kind of injury the plaintiff suffers is reasonably foreseeable, that is FASD disabilities and additional childbearing costs, all such injuries and costs are recoverable even if they far exceed what could have been anticipated. So a woman who's consumed a relatively small amount of alcohol, one wouldn't expect her child to have significant FASD disabilities. But if in fact the child does have significant disabilities, all of those can be recovered. Pursuant to the thin-skulled plaintiff rule, if the kind of injury the plaintiff suffers is reasonably foreseeable, the defendant will be held liable for any unforeseeable consequences that resulted from the plaintiff's pre-existing susceptibility or weakness. Consequently, a defendant would not be relieved of liability simply because a woman's unique genetic makeup or her age made her more susceptible to having a child born with FASD. Plaintiff's additional childbearing costs and the infant's FASD-related injuries are not too remote in law to be recoverable. Damages. The general principle for assessing damages is easy to state, namely putting the plaintiff in the position they would have been in to the extent that money can do so had the injury not been committed, had the wrong not been committed. However, applying this principle, particularly in the case of children with significant disabilities, is quite complex and involves calculations and assumptions, including the child's life expectancy, need for care. So in one case, a case called Cherry and Bosman, damages were assessed on the basis the plaintiff, who was 7 years old at the time of trial, would need care and support for 53 years. So they had to speculate what the child's needs would be over the next five decades. Okay, these cases generate multi-million-dollar claims and take years to resolve. A case called Ettinger, which was only resolved 15 years after the child was born, resulted in a damage claim of $3.2 million. A case called Crawford was only resolved 20 years after the child was born, and the damages were assessed at $10 million. Okay. Parents cannot recover at common law for grief at having a disabled child. But they can recover the additional costs of care and for additional supports that are required due to the child's disability. So children born with FASD and their parents typically suffer a range of losses that are recognized as being recoverable. Defenses. If the tobacco litigation is any indication, the manufacturers will raise numerous defenses. I was asked to review the defenses, statements of defense in the New Brunswick tobacco cost recovery legislation. They raised 7 common law defenses and 2 equitable principles. Now, I'd only been teaching tort law for 50 years at that time, and I wasn't aware of half of them. But what's significant is none of them were relevant. But you can expect the industry to raise. Okay, now, it's unlikely that any defense can be raised in terms of the child, in terms of the fetus somehow engaging in conduct that would justify limiting damages. But the parental claim for additional childbearing care and costs would likely be challenged on the basis that the mother's drinking constituted contributory negligence and gave rise to a voluntary assumption of risk. Now, the Supreme Court of Canada's decision in Dobson likely precludes the ability to raise any defense, because she owes no duty of care to her fetus. But leaving aside that problem, the defendants would have difficulty establishing contributory negligence and voluntary assumption of risk on the merits. In order to establish contributory negligence, you must establish that the plaintiff breached the standard of care. If a court accepts that a woman was uninformed of the risk, how do you establish that her conduct would give rise to negligence? You're holding her to be contributory negligent in regard to risks of which she has no knowledge. And a similar argument would apply in terms of voluntary assumption of risk. So it is unlikely that the alcohol manufacturers and suppliers will be able to establish the defense of contributory negligence or voluntary assumption of risk. So, the conclusion. And I'm sorry I've had to go quickly through some of this. I'm happy to make the PowerPoints available to anyone who wants them. I have a set of speakers version which has more detail. I have supplemental information to the charts, and we have the McGill Journal for any of you who want a more detailed explanation of some of these issues. Okay, common law principles of negligence established decades ago provide a basis for suing Canadian alcohol manufacturers and government liquor authorities for failing to inform women of the risks of FASD. Yet, to date, no such civil suit has been brought. The major barrier to such claims is not the law, but rather the challenges that even the best informed plaintiff have in suing a multi-billion-dollar defendant. Now, the lack of FASD claims is reminiscent of the situation with tobacco, which for decades was able to avoid being held accountable, even though the risks of smoking were well known in the early 1960s. The Canadian alcohol industry appears to be on a similar trajectory. In our view, Matty's view and mine, it is only a matter of time before the alcohol industry and government liquor authorities are sued and held liable. So, next steps. We're finally getting our article published. That is necessary to provide credibility to the argument. I know you're going to find this surprising, but our political masters and their minions don't pore over academic journals in terms of public policy initiatives. And so the next step is getting this information out. And that will probably involve more public speaking to legal audiences, writing op-ed pieces, etc., to get this information out. It's also going to be necessary to begin to build a coalition of organizations and agencies on board. There's a difference between we don't know, in which case you need research, and we don't care. And in many of these areas, it is not an issue of we don't know. It's an issue of we don't care. How do you build a coalition of people and organizations to make the government care? The threat of legal liability may well be one of those means. Thank you all very much.